Your rig is where you work, where you rock out. Your rig is your livelihood. So when that DPF light comes on, give your rig the respect it deserves. As for Road Warrior, stronger seals, better manufacturing, and it's made of metal that lasts. Less downtime and more miles on the road so you can haul longer. Respect the rig. Become a Road Warrior.
Welcome to The Long Haul, the podcast dedicated to empowering small carriers and owner-operators to drive their business forward. I'm your host, Adam Wingfield, bringing you insights from industry leaders, real-world success stories, and strategies to help you navigate the road to profitability. Whether you're just getting started or looking to take your fleet to the next level, this is the show where trucking meets opportunity. So buckle up, it's time to go the distance. What's up, y'all, and welcome back to The Long Haul, where we talk real freight, real stories, and real strategies for owner-operators and small carriers. Now, today's episode is going to feel a little different and a whole lot important. We're sitting down with Matthew Leffler, the Armchair Attorney himself, to walk through something most folks sign without even reading, and we're going to talk about that good old carrier packet. Now, before we get into it, let me state this clearly. This episode is for educational purposes only. We are not giving legal advice. Nothing in this conversation should be taken as legal guidance or a substitute for speaking with your own attorney. This is about awareness. So you know what's inside of those contracts, what the language is about, and how to protect yourself from signing something that you're not familiar with your signing. If you're a one-truck operation or small fleet owner running on thin margins, this episode is for you, and it's always a must. And as always, if this show brings you value, do us a favor, like, share, subscribe, and hit that link in the subscription so you can sign up for our newsletter so you stay plugged in with tips, insights, and tools to keep your business moving forward. Well, you know what? Without further ado, the fastest man in freight, well, we'll say the second fastest man in freight. We're competitors, right? My good friend, Matthew Leffler. Welcome to the show today.
Thank you so much, Adam. Let me be very clear. I was once fast. Those days are very far behind me. I was a sprinter, and I do not sprint anymore unless it's chasing the Twins. So thank you for having me. I appreciate it.
I'm excited. And this episode, like I said, is going to be really, really different. We're just going to dive in because one of the things that we get and some of the conversations and all of the discussions that wave around is signing carrier agreements, and really wanted to make sure we took the time to go through a carrier agreement and just some generic terms that are in a carrier agreement. So that way owner operators know what the meanings are, what the terms mean, what is it implying, what is it not implying. So we really, really wanted to bring someone on that was just an expert in that type of field when we go through this, because I think it's really important.
Yeah, I appreciate that. And again, I want to echo your disclaimer, Adam. Nothing that I say is meant to be legal advice. If you think you need a lawyer, you probably do, and it's not me. So definitely find a lawyer. Unless you're paying me, then maybe I am your lawyer. So thank you for listening. But I would also say it's important for people to understand what they're getting into. And that's the purpose of today's kind of conversation, is to give people a better understanding of what is contained in these agreements, what you might be able to negotiate, what you probably can't negotiate, and really what to kind of take away from that. So I'm excited to be a part of this today.
So I want to start off by talking about what exactly a carrier agreement is, a broker carrier agreement or a carrier packet. When you go out as an owner operator, a small carrier, if you're brand new, when you go book a load and you have not worked with that particular 3PL or broker, they're going to say, well, we don't have a carrier packet for you. We don't have you set up in our system. We're going to email you or RMI, however they communicate. We're going to send you a packet. You need to fill that out and agree to those terms to send it back to us in order for you to move that freight, correct?
Yeah, that's exactly right. So just to give people some of my own background. So I am a lawyer. I've been practicing law for 15 years. I'm an adjunct law professor at Michigan State University College of Law, where I really focus on transportation. I teach supply chain law to second and third year law students. So you're exactly right. The broker carrier agreement is like how I get the opportunity to work with a broker. These are typically called, I would call them contracts of adhesion. What that means is typically you don't get a lot of room to negotiate. If you even try to negotiate, they're going to say, hey, thanks, but no thanks. We'll find a different motor carrier. It's very similar to when you're trying to negotiate like a cell phone contract. Verizon doesn't really care if you redline, like they're just not going to listen to you. So it's important to understand that in some cases you can negotiate, you can push back, but in a lot of cases you probably can't. And so it's important to kind of walk through what are you agreeing to, and then hopefully what you take away from this. That's the real backbone behind these carrier packets.
And I want to go through a couple of that I've looked through, and I'm just going to go through some headers so that way we can kind of talk through it. And let's get into the meat of it. So typically in the first, somewhere along the line of a carrier packet, there's going to be a workman's compensation certificate of election. What am I signing?
So one of the big challenges for brokers, and just as for your audience who's listening, understand that the behind the scenes of these documents is the broker trying to make sure they will not be at fault or liable for anything. They're trying to make sure that you are following all the right guidance, you're providing the right insurance. So workers' compensation, this is something that every single employee must have. So if you are an employer and you're using W-2 workers, you have to have workers' compensation insurance. Brokers in this context are trying to verify that the driver who's coming to pick up this load has insurance, has workers' compensation insurance. Because what brokers want to avoid, and this is a different segue about AB5, but just briefly, if you don't have workers' compensation, someone may say, oh, actually, you're an employee of the broker. This is one of the guardrails that brokers put inside their contracts to make sure you're not going to claim that you're my employee. Because if you have workers' compensation, you are an employee of that entity. Now, if you're an owner-operator, you may not have workers' compensation insurance. You may not even be able to buy workers' compensation insurance. So there's elections you can take and say, hey, I'm an owner-operator. I don't have workers' comp, but I'm verifying that I am an independent business. That's really what's behind that workers' compensation piece.
That's really good because it's funny thing, and maybe not so funny, there's some carriers that have 1099 drivers that don't have workman's compensation that may be signing this out and not realizing what that even entails to. And then you look at it from a broker standpoint, they're not even verifying this stuff. They're just kind of just saying, hey, here, take it back.
And they're not in a good position to verify. You're exactly right. So this idea, and again, we're not going to go into the deep segue here, Adam, but misclassification of a worker is a massive liability. And if you do it wrong, you can face a ton of liability and you might have to pay attorney's fees. So making sure you classify properly is another segue that always important to think about when you're talking about the law.
There you go. Then you go down and you get into the agreement. Typically, the agreement always starts off with description of services. Yes. So from that standpoint, just basically saying that the broker agrees to tender to the carrier on a non-exclusive basis. What are we talking about?
Exactly right. So when this is all said and done, this is how the broker is going to pay you and what you're going to do. So you're going to promise through this contract, I'm going to do this stuff. And that's the service I'm going to provide, which is hauling freight from point A to point B, delivering safely, on time, and undamaged. That is really what you are promising to the broker that you're going to do. And the broker's the part that comes after this is, how is the broker going to pay me? Because they're going to condition what they pay you based on your performance. A contract is a promise to perform for consideration. So you're going to do something for money, and that's what description of services is. You will see this on every single contract, whether you're in trucking or anything else. It is what you're promising you're going to do.
Then you move down to the carrier operating authority, which is pretty cut and dry, saying, hey, you are going to maintain the correct interstate or intrastate authority the duration of time that we're going to do business. And I'm assuming, and maybe I'm wrong for assuming, I'm assuming that at no time should I have any of your freight on my truck and I don't have an interstate or intrastate authority. Am I correct for assuming that?
100%. So again, you are promising that you are legally authorized to do the services you're promising to perform. The broker is not the arbiter of whether you're qualified to do something. They're going to rely on, obviously, FMCSA and other software tools, but they are going to come to you and say, in this contract, you are promising me that for the entire duration of our relationship, you're going to make sure you're in good legal standing with all the right authorities to do the stuff that we do. Whether it's doing hazmat or whether it's doing liquid bulk or whatever it is, you are qualified, certified, and have all of the right framework on the federal side of what you're allowed to do.
Then it moves us into the carrier's legal and regulatory compliance. So that basically is just coming out saying that I'm acknowledging that I have to conform to all the regulatory activities. But there's a little clause in here that makes me a little curious in terms of it, because it says carrier will be responsible for indemnifying broker for such charges by paying broker liquidated damages, not as penalty, equal to any additional charges required to be paid and any cost of attorney fees incurred by broker in connection therewith.
I love legal talk. So liquidated damages is a special kind of damages that say, hey, I don't know how much this fault of your not having regulatory authority is going to cost me. So we're going to agree in advance that it's going to be some amount of money, whether it's a $500 or $1,000, whatever. Someone will put some liquidated damages in. Generally speaking, I do not see brokers ever suing motor carriers for liquidated damages. They generally don't do that. Now, indemnification, that is a special word that really just means you're standing in someone else's shoes. So imagine the best example is with an insurance claim. You hit somebody, the insurance company is indemnifying you. They're going to pay what you are legally required to pay on your behalf. So if you're a motor carrier, and we're going to have plenty of these indemnification clauses throughout this thing, Adam, because the broker is very clear. I don't want to pay anything. I'm going to make sure you, the motor carrier, is on the hook for whatever happens. So that's the idea of this, the liquidated damages and indemnification. It is just another way for brokers to continually insulating themselves from potential liability.
And then he moves on to the operating responsibilities, which is usually a long paragraph. It has a lot of stuff in that paragraph, and it talks about safety and unrated safety ratings. And there's a lot of things in regards to safety in that. Anything that stands out in that paragraph that should be talked about?
I think that the main thing is brokers do not want to control you. They don't. They do not want to control you, because if they control you, then they may be liable for employing you, making you a W-2. So what they're trying to talk about with operating requirements responsibilities is, you know how to buy a truck. You know how to get a trailer. You know how to license that equipment. You know how to operate that stuff safely. We are just going to put this in the contract that this is on you. This is not on me to be the guarantor that your truck is safe, your trailer is safe. This is them way of saying, hey, you know what you're doing. You're the expert. That's why I'm hiring you. Make sure you do all the stuff correctly.
You know, the thing is that takes us to the next one, which is receipts. And when I think about receipts, I think about, I just got a receipt for lunch just a few minutes ago. Like, I think about that receipts. But there was something really, really interesting into the delivery receipt that basically stated that upon taking possession of the goods, the carrier shall assume liability for the goods until proper delivery is made at the consignee. When that forklift takes that pallet and puts it on the trailer, I'm taking possession of the goods once the door closes, right? So that means that if something happens, like, whatever, and, temperature issues, whatever, pallet tips over, whatever, it's saying that I am the one that's responsible. Am I wrong?
The carrier is strictly liable for damages of the product inside that trailer. To your point, when the doors close, you may never have even seen how it was loaded. You might, as a driver, think, I want to go inside the warehouse or the distribution center and see how they loaded it. You may not be able to do that. You may never touch the freight. But the way the stuff is structured as a motor carrier, those doors close, that is on you. Now, there are ways to go back at the shipper or the receiver and say, hey, the damage didn't happen with my custody and control. But this is the idea. It is difficult to safely deliver freight on time and undamaged, even under the best circumstances. But those doors close, that is your liability. That is your possession. You have custody. You have control.
Then you move into no substituted services and diversion or reconsignment. That sounds like a fancy word for double brokering.
1,000,000%. They are saying, you're going to take this. You've already promised me you have authority, your regulatory compliance. You've taken possession. You will not double broker this. You will not give another person the custody and control. It is you who is taking this freight. And it is again, like double brokering is not really an FMCSA issue. They don't really regulate that. So they have some ways of protecting your identity and how you sign on to things. But ultimately, this is something done to protect them from making sure you're not double brokering it. If you do double broker, maybe they can sue you, but as long as it arrives safely on time, they're probably not going to do a lot. I mean, we see double brokering happening or co-brokering happening all over the place. Co-brokering, just for your audience, is when all the parties know that another broker is involved. There's disclosure. So you're exactly right. This piece of the contract is saying, hey, we're going to give you this freight. Don't double broker it. Don't give it to somebody else.
Yeah, it's good that they have that in the language too. And it's really clear up front. Then you move down into rates, which I think is really, really interesting when you go into the rates. And there's something in the rates that really kind of stands out to me. It says carrier and broker agree that any tariff, rates, accessorial, say that aloud 11 times, or rules and regulations established and or published by carriers shall not apply to any service unless specifically agreed to by carrier and broker in writing. Any changes in rates, charges, or rules and regulations shall be mutually agreed to and confirmed in writing, signed by both parties. And the first thing comes into my mind is detention.
It's important that you have disclosure of what accessorials you may be facing or considering. You're exactly right. Both parties need to know what it is. They have to agree to it. Detention's a funny thing. You can't change your detention numbers after you've accepted this contract. So this is when you're talking with that broker and you're having that negotiation. This is a place where you can push and say, hey, my detention's going to be X. That's what I'm going to charge. If you don't like that, I ain't taking this load. And it is not uncommon. And this is part of the broker transparency thing that we absolutely get to later in this contract, is that maybe the broker collects it and doesn't pay you the motor carrier. Maybe they do charge.
Maybe they keep it. Yeah.
Yeah. And they'll just hold it for themselves and not give it to you. You might not even know that. But the idea of this clause is a general understanding that we are not going to have separate agreements outside of this contract. If you and I over the phone say, hey, we're going to have detention as this, and then the contract says something different, the contract is going to win. So if you and your broker agree on something and you think it's correct, it may not actually be real unless it's inside the document in a way that someone can look at it and agree and digest it. So we want to have a meeting of the minds. It's a term of art that we say both parties know what they're getting into and agree to the terms in front of them.
And you know, that's crazy because a lot of times you'll have all these varying arguments that happen after the fact, but it's all in writing. And if you just take time and you see it, it's really, really scripted out that, hey, what we agree on in the beginning is what we're sticking to. So then you move down into payment, which is the next typical section that you'll find somewhere in a broker carrier agreement, which is interesting enough, is the carrier authorized the broker to invoice broker's customers for the services. Carrier authorized broker to invoice broker's customers for the service. The carrier, on the other hand, agrees to invoice the broker and only the broker and acknowledge that the broker is the sole party responsible for payment of its invoices for the services and assigns broker all its rights, not some, but all its rights to collect freight charges from broker's customer or any responsible third party upon receipt of payment of its freight charge from the broker.
This is all about the money, Adam. It's all about the money. And the money says the broker has exclusive rights to invoice their customer, the shipper. The broker looks at the motor carrier, your drivers, and says, I am your customer. You're going to invoice me. You're not going to invoice my customer. You're the supplier for me. I am your customer. Invoice me for anything that happens. Now, it is important to note that motor carriers have to get paid. They get paid. And the example I'll give, and many of your listeners and viewers will remember this, when Convoy began to wind down, IKEA owed, that was a brutal one. IKEA owed Convoy $500,000, $500,000. And what did IKEA do? They did not pay that money to Convoy because those motor carriers began to send invoices and emails to IKEA saying, hey, I moved your stuff. I want some money. And what IKEA did is they took that $500,000, they put that into a federal court, and they listed every motor carrier who moved that freight. And they said, you motor carriers, you can make a claim in this lawsuit for your money. You cannot come to me because we're not going to pay convoy and we're not going to pay you directly. So what this really boils down to is the broker, assuming they are financially solvent. It's an interesting time, Adam. So maybe that's not the case for all of them. But what they are saying is you are going to invoice me and I'll take care of the shipper. Now, there's factoring agreements that can be in play here. People get paid in a lot of interesting ways. The main takeaway is if you're a motor carrier, do not invoice the shipper. If you do that, the broker will never work with you again, and it will be very messy. Now, if the shipper is not paying the broker or the broker's not paying the motor carrier, there are mechanisms to get paid. But this contract, the way these stuffs are put together is you are going to pay me, the broker, from the shipper side. And if you're the motor carrier, you will only be paid through me, the broker. Do not invoice my customer.
And that gets us into the meat and potatoes. We're getting closer and closer to where this thing really, really starts to get interesting. It's interesting so far. The crazy thing is if you sit down and read it, it's an interesting agreement. It's common sense in some places, but in some places you're like, am I signing this? Because then you move into loss, damage, and delay. You always find this in all of your carrier packets. Loss, damage, and delay. Carrier shall be liable to broker and broker's customers. Broker and in addition to, plus, together, and broker's customers for the actual loss of, damage to, or delay of the goods under the carrier's care, custody, or control. According to provisions of 49 USC section 14706, like anybody's going to read that, during carrier's performance of the services. The term actual loss shall mean the full invoice price charged by the broker's customer to its customers for the kind and quantity. The full invoice price charged by the broker's customer to its customers for the kind of quantity of goods lost, damaged, destroyed, plus freight charges, less salvage value, unless otherwise agreed between a broker and carrier. What in the heck did I just read?
This is, again, the same piece we talked about earlier about indemnification and who's responsible when things go wrong. The motor carrier is strictly liable for the freight once it's in their custody and control. And it could be that you never saw the freight, you never touched the freight, you got bad loaded, you have no recourse unless you, again, if you go through the process after the fact, but you are taking responsibility for that load at the value the shipper determines. And so you might actually be on the hook for more than you thought you would be, because maybe you move it for 1,000, but this load is 300 grand. You're liable for 300 grand. You're liable for the entire amount of the freight. And so this is, again, one of these things we talk about these broker carrier agreements. They are written on behalf of the broker. There are not a ton of motor carriers. The big motor carriers certainly have this, but contracts that are written to be in favor of the motor carrier. This is in favor of the broker, saying the minute you take custody and control, those doors close. That's you. And that's why it's so important for you to, as a motor carrier, to understand who you're doing business with, the value of the freight that you're moving, and ultimately whether your equipment is ready for this kind of stuff. Because you go to a travel center and you're fueling up, someone comes in the back and rips off the tag and grabs a bunch of stuff. That's on you. That is on you when that happens.
And then, the crazy thing, there is an exception. It says claims based on concealed loss or damage reported to the carrier by a broker within 5 days of delivery will be treated as though an exception notation has been made on the delivery receipt at the time of delivery.
This is important because it's about speed, right? So the receiver wants to know that they got what they paid for. They want to know that what got delivered to them is exactly what they anticipated. And brokers want this too. Nobody wants to be in a position and say, hey, that thing you brought to me 2 months ago is missing 2 skids. Like, that is not what we want in the industry. And so what ends up happening, and again, in this kind of context, is you want people to move quickly and report fast. And so again, you may not even be allowed inside the dock when you get to the receiver. Maybe you can't even see what's happened, but the shipper and the broker have an agreement too. They have a version of this that's probably more shipper friendly, just so we can be clear on that. But ultimately, it's about making sure you disclose the damages as quickly as possible so that you, the motor carrier, like, hey, you guys hid this from me. I couldn't do anything about it, or it was loaded improperly, whatever. You want to make sure people are disclosing what's gone wrong before it gets too far away.
So another interesting thing is that comes down to the term that's associated with that particular clause, because then it says the term of this agreement shall be for a period of 1 year from the effective date set forth above and shall automatically renew for additional 1-year periods unless terminated pursuant to Section 11, which is a termination clause. Why is that term so important?
Well, it's how long you're agreeing to, right? So if you're a motor carrier and you're going to try and make changes of your pricing matrix, that might be difficult because this term is for 1 year. Now, parties can always change contracts if both of them agree. But the default for most business contracts, especially in business-to-business contracts, is a 12-month term. So this agreement's in place for 12 months. And if you don't say stop, it's going to automatically renew with all of the initial terms we had previously. That is not a bad thing because ultimately you could just say, I don't want to haul your freight, so go pound sand unless we change this contract. But most contracts have a sunset period. And in cases with business to business, which is what we're talking about, there is an automatic renewal. So this thing continues on for the foreseeable future.
Today's episode is brought to you by Trucking Hub. Now listen, if you're still bouncing between 5 different logins just to run your trucking business, you're already behind. Trucking Hub is built by a carrier for carriers, and it puts everything under one roof, whether it be dispatch, safety, maintenance, and even accountant and a driver app. Their dispatch runs on PC Miler and Copilot navigation, so the miles are right the first time. Now the ELD is FMCSA certified, tamper-proof, and trusted since 2017. And if you want to keep it all in one lane, you can even roll in company phones, text and video, and fax backed by nationwide LTE. Bottom line, this is the kind of system that's you spend less time hopping and more time hauling. Plans start at just $29 per truck, no contracts, no hidden fees, and you can try it for free for 30 days. Check them out at their website and get your time back. Then we move down to insurance. Insurance is really pretty much cut and dry. I don't think it's really any standard. You got to have insurance, and that's part of what you need to have. It lays out the commercial liability that you need to have. It tells you cargo coverages, workman's compensation if necessary, like we already discussed. So it kind of lays that out. One of the things it states, though, in a couple of the actual broker carrier agreements is that if the carrier's insurance is threatened, so it mentions the threatening behind the carrier's insurance. Is it threatened to be terminated, canceled, suspended, reduced, or revoked? Carrier must immediately notify the broker and take steps to reinstate or replace the applicable insurance. And then the carrier shall provide broker certificates or other evidence of foregoing insurance coverage upon request by the broker.
Yeah, the insurance thing is actually, I'm a lawyer, so I get really excited about insurance, Adam.
Yeah.
So the minimum insurance required as an interstate motor carrier is $750,000. That number's been around for over 40 years. No one's surprised by that. But what we have seen happen is enterprise shippers, and then as a result, the brokers that support them, are requiring higher and higher amounts of insurance. So $1 million, I've seen some that are $2 million, or sometimes even $5 million if you're hauling something really special. So this piece of like, how do we look at insurance? It's interesting because the shippers are kind of driving the conversation where you would think the federal government might be. But as it relates to like, you might be threatened to lose your insurance. If you're a motor carrier and you miss a premium, you're going to get dropped. And every broker, and I'd say everyone, most brokers have some sort of technology that is monitoring the insurance of their motor carrier partners. And so they're going to try and check this already. So if you think, maybe I'll sneak by, they may still find you, but they are telling you, you need to disclose and prove to us you have insurance. I would also go back to that Convoy example. When Convoy went under, a lot of the enterprise shippers went to their brokers and said, I need to validate that you have the financial wherewithal to survive. Prove to me that you are solvent. And so for the brokers in this case, it's more like, prove to me that you're insurable. If you have a big accident, you might get dropped. I want to know what is happening before I get surprised. Because the piece we'll get to it at a little bit is, When can brokers be held liable if you, a motor carrier, have a mistake? And we don't know that answer. It depends on the jurisdiction. So ultimately, the insurance side of things is have the coverage. Make sure that when you sign this contract, you actually have the insurance required. Because if you're running 750 and you agree to $1 million, you're in breach of that contract the moment you sign it. So make sure when you're looking at that insurance piece that you have the insurance required for that specific broker.
Now it gets to the more sticky part. It comes to that indemnification word. And indemnify. Carriers shall defend, indemnify, and hold harmless broker and broker's customers, their respective officers, all of that good stuff. And anything that's in relation to a judgment, fine, penalties, decrees, awards, costs, expenses, litigation, reasonable attorney fees, like the whole nine. And these are claims on account of loss or damage to property, personal injury, death, which is sustained by parties, loss or damage or delay in transit to goods, carrier breach of any of its representations, and carrier's failure to comply with workman's compensation for any claim of workman's compensation. Hey, my driver slipped on the loading dock with a shipper and he got hurt, and it's not the shipper's fault. What am I seeing in that?
This is where wars are fought and won or lost. Indemnification. It is two pieces to indemnification. There's a duty to defend, which we talked about. We'll talk about that in a second, and a duty to indemnify. When you have an insurance claim or someone hits you and you're in litigation, your insurance company has those two duties, to defend and to indemnify. The duty to defend is they will pay the legal expenses for their client. So for you as a motor carrier, you are agreeing to pay the legal expenses of the broker in a claim. That is what you're agreeing to. Indemnification is then picking up the bill and saying, okay, I owe all of this.
Wow.
And this is why these cases of nuclear verdicts and liability are so interesting. So like we look at the Hope Trans case. It's a motor carrier with 100 pieces of power. Their broker was Covenant. They were moving for USPS. The plaintiff is suing Covenant. They are saying you did something wrong by hiring this motor carrier. Hope Trans is dealing with their own liability. They are also going to have to pay the legal expenses of Covenant. Now, Covenant will advance those legal expenses because they have insurance. They're going to fight this tooth and nail. But this is how you see indemnification. I would say 99% of the time, Adam, you will not negotiate this. The broker will sit there and go, you redline this, you are done. This one piece is probably the most important component of the entire contract is indemnification.
That is nuts, man. Just like this, you sit back and you look at that power that's in the indemnification clause. It is truly something eye-opening, especially for the ones that may not necessarily read the implications that come behind it, especially financially. And then at the end of the rope, you're like, well, wait a minute. I didn't agree to this. Well, yeah, you did. And it's all in your indemnification clause. Then you start moving into something that you get into the messy stuff. And this is what I like to call the messy part of the agreement. This is when we start talking about confidentiality.
Yeah, buddy.
As part of a business relationship between a broker and a carrier, either party may be in or come into possession of information or data which constitute trade secrets, know-how, confidential information, marketing plans, pricing, or anything else considered proprietary or secret. So basically what it's saying is that you agree to not disclose on anything that you come into. I see no evil. You walk into a shipper that manufactures soup, and then you see the potatoes that's coming in, you see the onions that's coming in. You can't go home and say, hey, I know how they make soup at Leffler's. They have onions and potatoes, and they've got these trucks that's coming from this company, and it's coming from that company. They're coming from this, and it's coming from that, and they do this, and they do that. What are we looking at in confidentiality?
So confidentiality really, if everything is confidential, then nothing is confidential. Every single one of your listeners, everyone who's watching this, you have signed an NDA. Like whether you realize it or not, you've signed an agreement saying, I will not reveal confidential proprietary information. Now, normally, Adam, when we talk about confidentiality, it is the secret spices in KFC or the Coke recipe or the Dr. Pepper recipe. Like that's confidential proprietary information. the name of the dock handler at the shipper you go to, like that's not confidential, but they may say that it is. And no one, generally speaking, sues on confidentiality. So it's a protect all, it's a form. You're not going to really negotiate confidentiality. It's that piece on 371.3 that is part of this confidentiality that has to do with broker transparency.
Yes. So it's hidden. It's in confidentiality.
Absolutely. Now it does vary. So I've seen my carrier packets that break out 371.3 and say, hey, just so you know, you are waiving rights to access documents from a brokered transaction. So let me kind of set the stage.
We'll do that. We'll do that. Carrier agrees that broker charges to its customers are confidential and need not be disclosed to carrier. Carrier agrees. You agree, Mr. Leffler, that what I charge to my customers are confidential and I don't need to disclose those to you. Carrier specifically waives any right it may have. Carrier specifically waives any right, not just this right or that right. I don't care what right you think it is. Any right it may have under 49 CFR 371.3, except as may be required by law. The terms and conditions of this agreement and the information pertaining to any services will not be disclosed by any party to any other entities except to directors, officers, employees, authorized contractors, attorneys, and accountants of each party. What did I just get myself into?
So the FMCSA has a rule that says any party to a brokered transaction, which is the movement of freight, has the right to see the records. And what are the records? Who was the shipper? How much did the shipper pay the broker? How much of all the different pieces of money, what accessorials got charged? And under that regulation, 371.3, it is probably outside of broker liability, the most important thing for brokers today. Whether you're talking about TIA or you're talking about the load boards out there, this thing is incredibly important. What has traditionally happened, if you didn't have the waiver, and Adam, you're like, hey, I'd like to know how much money the shipper paid you for me to move this. I would say if I didn't have the waiver, I'd say, hey, you can come to my office in Ohio on Tuesday, and I'll give you an hour to look at them. And that's the only time you're going to be available. And if you said I can't make it there, I don't got to do anything. So the FMCSA has begun to target this thing called broker transparency. And they've done a proposed rule that essentially said, if you request records of the broker transaction, I got to produce them in 2 days in an electronic format. That went through 2 different comment periods. And ultimately, the FMCSA did not change the rule. Instead, they said in May of 2026, we'll once again have a supplemental rule and we'll talk about broker transparency. Now, all of that is fine. That's all that's happening. But in this document is a waiver. And this is the question. If I am a broker and I have you sign this, waiving a right that you have under the federal regulations, am I able to not produce the records? And that has been what brokers have relied on. 99.999% of all broker carrier agreements have this waiver. There is one case right now that I'm aware of, Pink Cheetah versus TQL. And the question in that lawsuit is whether a motor carrier can waive this right at all. And we don't have an answer. It's still in the initial phases, but that is what is at stake. The stake here is, do I, the motor carrier, get to know how much you, the broker, were paid by the shipper? Now, there's other pieces, the clause right after, which we'll talk about solicitation, but that is 371.3. Again, I'm going to do a quick little aside so people understand where this comes from. In the old days, Adam, there was one transaction. The motor carrier was looking for a backhaul. They would work with the broker to find the backhaul. That shipper doing the backhaul would pay the motor carrier directly. And the broker would say, how much money were you paid? Because I get a piece of that. It was one transaction, but multiple people who were interested. Today's world is different. Today's world is shipper and broker have a relationship. They do a deal. And then you, the motor carrier, and the broker do a deal. They're separate deals, but they're related. So this broker transparency thing has captured the imaginations. Thousands of people have commented on it. And that is exactly what this waiver of 371.3 is. My suspicion, Adam, is the supplemental rulemaking coming in May of next year will likely tackle waiver head on. Because initially the FMCSA said, we don't care if there are waivers. We'll have new rules, but the waiver remains. They might be challenging that waiver, and that would fundamentally change how the industry behaves.
I thought it was interesting. You brought up the Pink Cheetah, TQL, and when they dismissed the most recent hearing, when they made that dismissal, the thing that stood out to me was in the footnote.
Absolutely. Footnote 3, buddy.
It was in the footnote, and the footnote basically said, we're dismissing it, but I don't like how you guys do that waiver thing. And that's basically what it said. And I was like, that could be a problem. Like, because they
put it in perspective.
That's just looking. I'm like, they put it in a footnote on the actual court docket. They put it in a footnote. So I thought that was interesting.
Yeah, what happened in this case for the ones who are listening, so Pink Cheetah moved a load of ice cream for TQL, and they asked for records of the transaction. And TQL said, as you could expect TQL to say, go pound sand. Like, we're not giving you anything. And they got a letter from an FMCSA official, and the official said, hey, you should produce this to Pink Cheetah. So they did. And then Pink Cheetah looked at the number and said, you made 40% on this deal. I want to know what happened for the other 15 loads that I moved or 14 loads that I moved for you. And TQL said, now absolutely go pound sand. We're not going to help you. Yeah. So Pink Cheetah sued in federal court and said, we think the waiver is illegal. And to your point, the court said, that's not a claim. Like, you don't have the right claim. This letter from FMCSA is not an order. You can't do this. However, on page 7, footnote 3, the judge in a very descriptive passage says, if you want to try again, you want to try and sue again, say that the order is the rule itself. Say 371.3 can't be waived. Make that argument, and I will take that case. And I've said this to many brokers, and this is probably the most controversial thing happening outside of, again, broker liability, for brokers at least. Okay, if I'm a motor carrier and I ask for those records and you don't give them to me and I sue you one time for this waiver clause, the broker's probably going to deal with that just fine. But if 30 motor carriers do it, or 100, or 1,000, or 10,000, it's a fundamentally different thing. And so this is setting the stage for what will likely be some of the most controversial litigation between motor carriers and brokers. And it's about this idea that some motor carriers believe that some brokers make 30 or 40% all the time. And that's not true in the data, but that is the story that's being told.
Yeah, that's it. It's going to be interesting. Then you peel down a little bit further and go into non-solicitation, which also is another interesting topic because it says it agrees during the term of the agreement, which is 1 year. But like you said, at the end of that 1 year, it automatically renews. So now it continues to renew unless you terminate it in a terminating agreement for a period of 1 year from the date of the termination. The carrier agrees during the term of this agreement and for a period of 1 year from the date of termination of the agreement. I haul a load for Leffler's Express back in 2000. I signed a carrier agreement with Matthew Leffler in 2000. Haul a load of ice cream in 2000, okay? No biggie. 2025, I said, you know what? I remember back in 2000, I used to have this ice cream shipper that I used to deal with back in the day. And you know what? It was through Leffler's Express. I go back to that shipper and I solicit that shipper. According to the language here, because the agreement was never terminated, I never terminated the agreement.
It automatically renews. It's fine.
It automatically renews. Are you saying that I could be liable here?
100. Well, first of all, don't take legal advice from the show.
Okay. Yep. Exactly. Exactly. Let's just talk. We just talk.
But You're exactly right. So we normally see non-solicitations in employee agreements. So I work for a company. I'm a salesman. I'm really good. I go work for another company. My ability to go call on my old customers is stopped because I have a non-solicit. I can't go call on the company. I can't go call on my former coworkers. That's what a non-solicitation in employment looks like. In this circumstance, it's a business non-solicit. Listen here, motor carrier. The only reason you get to know this guy or gal at this shipper is because of me. I brought this to you. And if you're going to work with me, I'll give you loads. But once we're done, or even if during the period, you can't go call on them directly. You can't back solicit. But if you leave me, we cancel the contract, 1 year, you can't call on them. And if they find out, what would likely happen, and again, it's rare, but it could happen, is you would sue the motor carrier for violating the non-solicitation agreement and saying you agreed, and I'll get an injunction. I would stop you from working with them. I could ask for your profits or your revenue to be disgorged, given back to me because you don't have that right to do it. And these cases, like non-solicitation, it is not like a normal liability case, Adam. It is you pay your own legal expenses. So you have to hire a lawyer to fight the non-solicit in that court, in that jurisdiction, and it could cost you $10,000 or $20,000 a month. So I don't see people suing on that with the B2B stuff as often, but will they send a terse letter? Oh, you bet they'll send a terse letter.
That is crazy. And how the wording in these language, if you start to go back and really read it, but you got to remember this now, we have had 43 minutes and 19 seconds to go over this part of the carrier agreement. But typically when it comes down to a carrier that has to sign an agreement, you got every minute or 3 minutes or I'm going to give it to somebody else. So you
100%.
don't have so it's almost like you're forced against the clock too, to make a irrational decision without knowing exactly what you're signing for.
Well, the advice I would give to a motor carrier who's in that time constraint is find the brokers you like working with. Compare their contracts. There are things you can look at. Like you can look at what is the solicitation period? What is the process for resolving disputes? Do I like to work with them? Do they pay me on time? So there's things you look at after the fact. But to your point, it's a contract of adhesion. You have a very short window, and if you don't sign it, you're not going to get to do it. So you have a choice. So do you want to keep your business running, or do you want to stop and hire a lawyer to come look at your contract in the next 45 minutes?
And then you get down to the dispute resolution. You talked about dispute resolution. You dig down into the resolution in the arbitration part of the dispute resolution. That's where it also gets sticky too, because there's so many different lines and how it's interpreted down into that. And so they're thinking about a written demand for arbitration must be mailed to the other party within 18 months of the party's actual knowledge of the occurrence of the claim, breach, act, or omission, or given whatever controversy. Okay, whatever, right? As to any dispute or controversy under the terms of this agreement is a proper subject of arbitration. Yep. No suit in the law or in equity on such dispute or controversy shall be instituted by either party other than the suit to conform, enforce, vacate, modify, or correct award arbitration. So that sounds like a bunch of legal jargon that only an attorney would understand. But go ahead and just kind of give me a summary of what I just read.
What it means is you're not going to get your day in court. Full stop. This contract, like many contracts, will say you are not allowed to sue me in court. You cannot go to the local courthouse and sue me. Instead, we have a process. This process is arbitration. Sometimes it's mediation. But the reality is, like, these companies, one, do not want to be in court, and two, don't want to have a jury. And so you'll see waivers or permutations of the only way we resolve our problems, our differences, is through binding arbitration or mediation, but we are not going to go to court. If you filed a lawsuit in court, the other side will say, we want to move this to arbitration. We don't want it to be here. And the court may say, I agree, get it out of my courtroom. It's got to go to arbitration. Even if the terms are not fair, we are not asking what is fair in contracts. We are saying, what did two sophisticated parties agree to? So that is what arbitration clauses are all about. You see them in employment context. You see them in every contract you've ever signed. You will always see these. We don't want to litigate things in court. Arbitration can be more cost effective for both parties. But the bigger thing is, generally speaking, they're confidential. So you can't go talking about what happened. You're not going to have social media posts in court. Everything is public unless you seal it. So we're going to fight, but we're going to fight privately and in a very different environment.
Wow. And then you go to the governing law and just, hey, you've got a broker in Utah and you're in North Carolina, and then you want to fight that particular broker. The governing law is going on based on the state on where that particular broker is. So if you want to fight me, you got to come get me, and that's kind of what I get out of that.
Yeah. And then what's going to happen the next, all the next sections we're going to talk about, these are all we call them boilerplate. Like this type of word, these type of clauses are in every single contract, no matter what. And they're all generally speaking, in favor of the person who drafted the contract. So where is a choice of law? Where's the choice of forum? What does a waiver mean? That's all going to be in the stuff we talk about next.
So you go down, you start talking about counterparts, electronic signatures, incorporations of recitals, severability, cost expenses, assignment, successor, and assigns. What are those all about?
When we talk about who gets to do what, how do you communicate these things? Notices, who gets to be notified when the contract is being changed or modified. You can't take the contract and sell it to somebody else. You can't say, hey, I'm going to give this contract to my buddy and he can take over for me. It only happens if both parties agree to it. So just like we had you can't co-broker things, you can't give this contract to somebody else. Now, that being said, if you sold your business as a stock transaction, you sold the stock, the new company could take over these contracts, but there'd be some level of notification that would take place. We have things like the governing law. So you're going to agree inside this contract whose state law applies. Is it Illinois? Is it Ohio? Is it Tennessee? You're going to agree to that stuff in this kind of back half of the agreement. The entire agreement clause, this is and again, every contract has this. It says, this is our agreement. If you and I talked on the phone or talked through email, we said something different, if it's not inside the four corners of the contract, it's not real. It's not real. And this idea that you can I know him, we said it was fine. They're going to say, that's cool. We're not going to do that because it's not part of the contract. That's why when you change things or you have a different understanding, you need them inside of this document. They have to be inside the contract.
Wow. And like I said, man, we could sit back here and we can dissect it over an hour, or you can go and sign it in 3 minutes. But there are certain things, and I hope that the listeners got value in just having their lens and their eyes open to certain components of the carrier packet, because like you said, it's a lot to digest in there. If you feel like that there's a need for any type of legal advisement and you feel like you've been done wrong, then you might want to pick up that phone and call and look for an attorney. But we found some interesting things from an educational perspective today, and I'm so glad that we took the time to break this down because quite frankly, I don't think that's been really talked about enough.
I mean, I think that everyone has the aptitude and the attitude to understand what they're getting into. This business is very difficult, and these contracts are made to be difficult to understand. And so hopefully when people are signing these things and going out to the market, they're at least have a little bit more tools in their tool belt to understand these things. To your point, if you think you need a lawyer, you probably do. And you should always talk with a lawyer if you're in a situation where you're not quite sure what you're supposed to do. But at the end of the day, these things are written on behalf of brokers for brokers. And if you think you need representation, you should get a lawyer. They're worth their weight in gold.
Man, that's awesome. And I appreciate you putting out there. And again, always just appreciate you joining us. If anybody wanted to get a hold of you, you do some amazing things in terms of content as well. You got a great podcast. If anybody want to get a hold of you, want to follow your stuff, how would they do so?
I would just look up Armchair Attorney or look up my LinkedIn is where I have a lot of stuff, or X. I'm on every social media platform. I begin teaching again in the spring, so I'm excited to get back to Michigan State. Go green. It'll be a good time.
It's funny. Back in the spring semester, I'll be going back to school and studying business law. So I didn't tell you that, but I'm behind you.
Maybe maybe an adjunct for you. I could teach you a couple courses.
We're gonna have to talk about that. Well, all right, y'all. There you have it. And man, as always, big thanks to Matthew Leffler for joining us and walking us through the carrier packet section with us and helping us understand what's really being put out there. Again, let's be crystal clear. This episode was not legal advice. If you got questions about a contract that you sign or when you're about to sign, you're going to need to talk to a qualified attorney. Our goal here was to educate, empower, and make sure you're just not hitting the sign and hoping for the best. So because in this industry, what you don't know can absolutely cost you. If you found any value in this episode, don't forget to like, share, subscribe to The Long Haul, and make sure to join our newsletter where we break down every episode and give you tools, templates, tips built for the small fleet world. Until next time, protect your paper, know your terms, and never sign blind. Take care, everybody. I'll see you on the next one.